So welcome everyone to the Sorry Not Sorry, How to Win with both US and Canadian Privacy. We have a lot to cover here today, so we're going to get started. I am Jody Daniels. I'm CEO and privacy consultant at Red Clover Advisors. We are all things privacy consulting. Think of us as like the privacy operations people to help you get done the long list of privacy requirements that we're going to be talking about here today. And this is a super awesome, amazing group of panelists, and delighted to have this webinar because these are fellow friends in the privacy consulting space. So Sharon, please introduce yourself to everyone here today.
Hi, everyone. Jody, thank you so much for having me. My name is Sharon Bauer. I'm the founder of Bamboo Data Consulting. We are also a privacy consulting firm in Canada. I started off my career as a litigator for 10 years, pivoted into privacy. At Bamboo, we help organizations identify the hidden privacy risks, try to figure out how to incorporate privacy into their business strategy, implement it, and we also act as virtual privacy officers and privacy coaches as well. So thanks so much again for having me.
Absolutely. And Kat.
I'm just going to copy paste what everyone else said. So I'm Kat Code. I'm the founder of Binary Tattoo. I also do privacy and data strategy. I do come from the engineering background, so also everything else, policies and privacy operationalization, but I also look at design, privacy by design and design and architecture for privacy safe products and services.
We are so excited to get started. This is going to be so much fun. We probably could spend like hours talking about all this because in our pre-planning, we were giggling and having fun and just geeking out on all things privacy. But to set the stage, we are going to be talking about US and Canadian privacy as it relates to companies. And we know that there's all kinds of interesting, maybe personal privacy kind of things. And I encourage you, if you are not already following everyone here on our panel, please go do so. And you will learn all kinds of fun and interesting facts and personal tidbits as well. But today we're going to try and cover so many amazing topics. And we're going to cover like little snippets so you get a decent understanding of each side. And then when you're interested in digging into more, please reach out to everybody. Now, to get us started, I like to sometimes do polls. So we're going to start with a poll. And the very first poll is to be an organization's footprint. So who are you? We want to know who we're talking to. Which best describes your organization's footprint? Do you operate only in the US, only in Canada? You're in both, you're planning to maybe expand, or you're not sure. I'm hoping we don't have too many not sures, but you never know. All right, thanks everyone for participating. Just gonna give you just a few more moments to click. This is a really easy one, everyone. Everyone should be able to vote on this one. All right, so where are our people? Okay, 64% of you are in both countries. We have 22% in Canada, only 9% of you in the US. 5% are planning expansion, and we didn't exactly tell you which direction, but that's okay. We like expansion. And I'm so glad that 0% of you were unsure. That is amazing. So, with that being said, we're first going to talk about consent, but just because of the way I have my slides, Sharon, is it okay if we actually start with our cookie consent and then we'll kind of skip to consent? Because we're going to make this be really fireside chatty, and we don't have a lot of slides. This is my big slide. Everyone ready? Our cookie banners required. So Sharon, I'm going to send it to you first.
Awesome. First of all, can I just say how I love that there's so many Canadian companies, I think, here. So thank you for representing Canada to those on the webinar. So when we're talking about cookie banners in Canada, I'm going to say in general, for the most part, cookie banners are actually not a requirement. It is becoming a best practice for sure, but it is not a requirement. And we're seeing more and more companies using cookie banners as good practice because many of those companies have to now comply with Law 25, which is Quebec's privacy legislation, or it's part of Quebec's privacy legislation. And under Law 25, what it says is if you're going to use technology to collect personal information that profiles, identifies, or locates a user, you must seek express consent. Now, if you look at that language, you can interpret that then you need a cookie banner to get express consent, because to profile, identify, and locate using technology, you're most likely using cookies. And so in that regard, if you're going to collect any of that information from Quebec residents, you're going to need a cookie banner. Now, I know that internally we had discussions, well, how do you know who's coming from Quebec or not Quebec? So either a company can say we're going to have a cookie banner, irrespective of where individuals are coming from, or they may geographically target cookie banners based on where individuals are coming from, based on the information in their IP address. So generally, no, Canada does not need a cookie banner. Quebec does. Best practices, have a cookie banner.
And in the US, we stick with our it's complicated approach. In the US, with the exception of if you are targeting or using any kind of data like health data, which is a really broad definition, or kids data, those are like our special exceptions, then generally speaking, you do not need a cookie banner in the US. We also have best practice where we're moving to more cookie banners, often because people want to follow a global approach. The other kind of unique challenge is some of the laws, namely in California, CCPA, they have a at or before the time of collection notice requirement. And some people have interpreted that to be, oh, I should have a cookie banner. And others have interpreted that to be, no, I don't need a cookie banner. So you have a little bit of an interpretation. Privacy professionals all have their own views of these situations. And then you also have kind of the state by state approach. So Jody's in Georgia. What do you do about me? I have no rights, no privacy law. I still get banners all the time because sometimes people have chosen to do that. So just like what you were describing, Sharon, with that best practice, what makes the US extra complicated is we have a lot of pixel litigation here, especially, again, in the state of California, but also a couple other states like Florida and Pennsylvania and a couple others. The pixel litigation, for those of you not familiar, often is looking at wiretapping and a couple other kind of similar laws where essentially they're using an older law and saying that technology required consent to be able to do the wiretapping, and cookie banners might not have been present, therefore there might not have been consent. And so as a mitigation measure, we are also seeing more cookie banners, but they're all over the place. Some are just notice, some are you can manage your settings, and some are full-blown opt-in consent. The last piece I'll say when it comes to all things cookies in the US is if you are going to have a banner, we do have laws that say that banner needs to be symmetrical. And very specifically, even if you don't have a banner, but you just have the preference center. So I get to manage my settings. Maybe you had it as a link. I click manage settings. You need to be able to have that manage settings have an accept and reject all button. The US is very specific in many of its laws, one click opt in, one click opt out. And symmetry, no dark patterns. So no fancy colors and things like that.
Jody, may I ask a question? And
100% ask a question.
I'm learning a lot from you now. Do the cookies need to be off by default?
So in the US, you do not have to be off by default unless you are a health-related targeting situation in select states. So many have interpreted Washington state under the My Health, My Data Act to be considered sensitive data. Therefore, it would need to be opt-in. And kids data is kind of also complicated. So typically for kids data, most people are just ignoring and not doing targeted advertising if you're very specific on kids. And then health is also unique in a couple other states that we're starting to see. So Virginia has a couple situations and a few other states. But generally speaking, if you're just trying to target me to buy more clothes and more goods and more services that are not health and kids, I am not default off.
Okay,
You can target it away.
yeah, so I do want to add for Law 25, for the purposes of identifying, profiling, locating, those cookies need to be off by default. So that's a bit of a difference between Quebec and US.
Thank you for pointing that out. So we could talk all day long about cookies. We were like, how are we going to even stop this? Now, you, Sharon, appropriately asked a question. And you know what I forgot to tell everybody? They also can ask questions. And there's like a little Q&A box at the bottom of your little Zoom webinar thing. So put your questions in there. And we are going to try and take as many of the questions as we can. So now I'm going to stop sharing. And we're just going to have a lovely fireside chat. And we're going to talk about regular old consent here. So I'm going to pass it back to you, Sharon, to help us understand beyond cookies, what else we have to worry about when it comes to things like consent.
Sure. And Kat, feel free to jump in. I know you know all this stuff too. So the thing that I think we need to kind of create a foundation on is that Canadian legislation is founded on consent. So we are a consent-based legislation. So unlike the GDPR that has 6 lawful bases for the collection, use, and disclosure, we have one, and that's consent. Consent in Canada can either be implied, where there's a reasonable expectation to the collection, use, or disclosure, or of course it could be express, where it's outside the reasonable expectation of the individual, or there's collection, use, disclosure of sensitive information or potential harm to the individual. And of course, there are a few exceptions to consent altogether. You heard me talk about Law 25 from Quebec. That's where, there was a lot of focus on consent. Quite honestly, none of which is groundbreaking. I think we all know this, except that it's prescribed now in the legislation. So consent needs to be clear and simple. It must be freely given. It must be informed consent. So you must identify the purpose for the collection, etc. And it must be separate from other information. Now, the one thing to remember, and something that is prescribed, is that simply asking for consent doesn't mean that you have informed consent. And it doesn't mean that once you collect consent, you can use it for anything. You always have to map it back to the original purpose that you got the consent for. So to recap, express consent, you need it for sensitive information. As I mentioned before, you need it when you're using technology to identify, locate, or profile an individual, as well as for biometrics. If I may, for 1 minute, I think it's really important to also touch on our anti-spam legislation. So it's called CASL, Canada's anti-spam legislation. And when you're going to send commercial electronic messages, so emails, SMS, social media messages, etc., you must have consent to do so. And once again, that consent can either be express or implied. Now, you can rely on implied consent when you have an existing business relationship, as an example. So if I'm a customer shopping at a retail store, I have a business relationship with you, you can imply that you have my consent to send me commercial messages. Or it could be a conspicuously published email where my email is available on my website and I didn't say, please don't send me your messages. And so long as your message is relevant to my role, you can send it to me. So those are examples, and there's a whole list, but examples of implied consent. Some companies, and this is a very kind of strategic decision, will decide, even though we can rely on implied consent, instead, we're going to seek express consent, which is harder, as you know, to get. And you may wonder, well, why are they making their life so difficult? It's because express consent does not expire. Once you have express consent, you can send out those commercial electronic messages indefinitely unless the individual withdraws their consent. Implied consent, on the other hand, you only have 2 years before it expires from the last activity that the individual participated in. So as a consumer, if I purchased an item from you, you have 2 years to send me those commercial electronic messages before it expires. So that's something to consider. And there is quite a bit of focus on CASL, which I know in the US is canned spam.
I'm just gonna,
Excellent.
yeah,
Oh,
jump
Kat,
in
go
to
ahead.
finish sort of the Canadian cycle before you mirror it to the US is the opt-out. So when you are on, especially Castle, on an email list, you have to have some method to unsubscribe. And what I've seen a lot of people doing, and I don't think we're covering it today just because we don't have time, is individual rights, which is the ability to request a copy of your information, to have your information deleted, all of that stuff, which is a whole other topic between Canada and the US. But what I'm seeing is companies are not making it easy for individuals to unsubscribe. If your clients don't want to be on your mailing list, why are you keeping them there? So like, make it easy for them to unsubscribe, because what they do otherwise is they ask to be deleted, which are two very different things. So if I want to be in your database, but I don't want your newsletters, and I click on unsubscribe, you can retain my data and do analytics on it and all sorts of other things, because I've already given you consent to do that. If you don't give me any other option than delete me, then I'm going to have to ask for all of my data to be deleted from your systems. And now you've lost the record of purchases or any other kind of information that would have been useful to you for marketing or as a business. So for your own sake as a business, for the usefulness of that data, make sure you do have a distinction again between the unsubscribes and the delete all my data.
Great point.
I have a couple questions back to you all. When we talk about getting express consent, can I bundle? I want to use it for purpose A, B, and C.
No, you should not be bundling your consent.
Okay, we can't bundle. And then what about B2B? So the biggest B2B question, if anyone here is here, I am anticipating they're going to ask, can I send cold messages to people? I got my list maybe from a ZoomInfo or like company. Can I send a cold message?
Great question. I will say it may fall under one of those exemptions for conspicuously published. So to use ZoomInfo safely, what I would do is if you get a contact information, I would go onto that individual's website, see if you can find their email, or maybe their email is posted elsewhere, as well as their title. You can use that email so long as you find it elsewhere and there isn't a message associated with the email to say, we don't wish to receive your emails. And that email that you send to them has to be relevant to their role or function within their job. If there's no linkage between the email and what they actually do at the company, then it may not be valid and you won't be able to send it to them.
Thank you. Well, so the US version of consent is we don't really rely on consent all that much here in the US, with some exceptions when it comes to sensitive data across some of the different states who define sensitive data as opt-in, but not all states, one, define sensitive data as the same, and two, not all states require opt-in for the use of sensitive data. For example, California does not require the opt-in for sensitive data. Virginia was the second state, and it does require opt-in for sensitive data. When our kids, again, is another bucket, and everyone here defines kids a little bit different. Some are 13 to 16, some are under the age of 18. For kids data, when it comes to things like advertising, again, consent is required. And for our national kids law, which is COPPA, which is 13 and under, you often do need parental consent for the use and collection of that type of information. But generally speaking, we are a business purpose situation. Jody and Georgia, again, I have no privacy rights, so most companies typically can kind of do what they want with my data. But for the 19 states that have a passed and signed privacy law, many of them, but not all, have business purpose. But the business purpose is not as specifically defined as it might be under GDPR with our 6 legal basis. It's not specifically consent. It's a business purpose. So that's always fun and interesting. And in terms of our email marketing, it tends to be more of an opt-out situation. If I can if I have an email, I can send it to you, but I need to be able to opt out. And you have to make sure you honor that opt out. There's a period of time within 10 days that you have to be able to have that. And from a texting scenario, though, that is an opt in for marketing messages. And so the kind of two interesting things that people get challenged on here, and a lot of litigation on CAN spam and our texting, which is TCPA. And mind you, there's also state TCPA laws, everyone, not just national. The texting and email, it's between marketing and transactional. So you have to really review the message to figure out how much marketing is in the message, because sometimes people try and say it's transactional, but then they sneak marketing in. And then as soon as you do that, it's no longer actually marketing or actually a transactional message. And there's a variety of criteria that you have to do to be able to do that. And it's very specific. So we're a like weird pile over here when it comes to consent. All right, Kat, one of the biggest questions we're always getting, we're just going to set the stage right now real early. National Canadian and privacy law. Do you have one? Is it getting updated? Where are
From
you?
2001. PIPEDA, PIPEDA, whatever the heck you want to call it. PIPEDA is, yeah, it's from 2001. And if you like go back to that year when like Facebook was in its infancy and people barely used the internet, well, we did, but we still had dial-up in 2000.
Dial-up, ding,
So,
and you remember?
Yeah, we vastly need, and there was no AI, like we vastly need an upgrade. What's happened with our political issues is they keep proposing a national law and then we keep going to new prime ministers and new elections and it keeps getting shelved, and so we don't have it. So from a US perspective, or new Canadian companies to privacy, each of our provinces has their own privacy commissioner, and each of them actually sets their own rules. So there's the superseding national law, which again, at some point will be updated, which we hope, Sharon, right? Yay. It was also supposed to include, and hopefully we have time to touch on it, this AIDA or IDA, which is an AI Data Act, which would have a separate thing specific to AI. Yeah, it was supposed to be updated to include more about children's privacy, which we don't cover well, more about the evolving digital technology and access, which we don't cover well. And it would include all of this stuff. So a lot of our stuff is kind of guidance. Now the individual provinces very much handle health. Like each of our provinces have their own health regulations. Some of them have some extra things. So we've touched on this already. Quebec, who is not its own country, but from a privacy perspective has what we call the CAI, which is the Commission d'Accès d'Information, which is the CAI. Because I'm a privacy geek, like we are, I love them because they have set so many parameters, and they created Law 25. So Law 25 says you have to run PIAs if you have sensitive information. They have transfer impact assessments, which I think we're covering next in cross-border transfers. They have their own borders. So, outside of Quebec is a border to them. They have their own biometrics law, which hopefully we have time to cover. So they have a lot of their own regulatory guidance. You also have to have like a data privacy officer as oversight, which like we love, because that finally gives us teeth to be able to tell the Canadian companies, if you're operating in Canada, which typically includes Quebec, you have to now abide by these GDPR-like standards, which is helping us because we don't have a national standard. So like Sharon alluded to earlier, the Quebec standard has sort of become the national standard because we always include Quebec, and therefore we have to meet that standard.
I was at a privacy conference several years ago, and regulators from many of the Canadian provinces were there. And I will never forget the lovely woman from Quebec who said, and I quote, "We are the California of Canada." So for everyone listening who understands from the US side the uniqueness of California, there you go. Quickly, we don't have a national privacy law that is what would be considered a comprehensive privacy law. We have in the US a sectoral approach. There is a national health law called HIPAA, but it's very actually unique. It doesn't cover every single piece of health data. It really only covers in a very certain type of situation. So a lot of times people think all health data equals coverage. Not true. From a financial transactional perspective, we have the Gramm-Leach-Bliley Act that covers financial transactions. Doesn't cover everything that a financial institution might also do. We have our CAN spam, just like we talked about, that covers email. We have our national texting legislation. So we don't have a comprehensive privacy law. There have been introductions, there have been tries. It has almost kind of maybe moved forward, and then it's died for a variety of reasons. And so we don't have one now. And my prediction is maybe one day we'll get one, but it's not going to be today. So that means we still have to keep with our two different countries, and we have a lot of cross-border that is happening because, as we learned earlier, we have 64% of our companies here are in both 64% of our companies that are participating here are in both countries. So talk to us a little bit about cross-border. What does that mean for people listening?
Oh my God, such a big topic. And there are lots of questions around it. So I'm gonna try to keep it tight and to the point. Going back to Law 25 in Quebec, any data leaving Quebec requires a transfer risk assessment. So it can go from Quebec to Ontario, from Quebec to BC, still needs that transfer risk assessment to identify the level of protection that data will receive in the other jurisdiction and to ensure that it receives the same level of protection it would in Quebec. Putting that aside, because that is its own topic, a lot of companies are wondering, can I store data, Canadian data in the US? Can I store it in Canada, but through AWS or Google Cloud, which are both, for example, US companies? What is allowed? What is not allowed? What does the law say? In general, Canadian privacy laws do not explicitly mandate the personal information must remain in Canada. There are some exceptions. So BC and Nova Scotia, as an example, have public sector laws that do require public bodies to maintain data in Canada. Also, there's some laws like Law 25 or the Privacy Act that, although don't explicitly mandate that all the information remain in Canada, it does impose really strict requirements on how data must be handled. So a lot of these organizations find it easier to maintain it right here in Canada. But going back to the cloud and where can we store the data? Is it okay to store it in AWS, in Canada, or in the US? I want to kind of take us back to the Cloud Act. So the Cloud Act is an act, a US law, that allows law enforcement to access data even if that data is stored in servers in another country, so long as US courts issue a warrant or a subpoena for that data for a criminal investigation. So in other words, as a Canadian company, if you're still storing the data in Canada on AWS, Google Cloud, Azure, etc., US law enforcement may still have access or can gain access to that data, even if it is stored in Canada, because Amazon, Google, etc., Microsoft are American companies. Now, it's not as easy as we want that data, give it to us. There are hoops that they have to go through. They're not significant hoops, so they have to go to court. They have to justify why they need the information. It has to be for a criminal investigation. And those US companies that are storing the data must provide them with the information. Now, we know that there are lots of terms and service agreements that will say, we will fight that request and, we're not just going to hand it over. But at the end of the day, they likely will have to hand it over. They also don't need to give you any notice or consent to hand over that information to US authorities. They may, in their agreement, say that they will notify you. That's good. You want that in your agreement, but they definitely don't need your consent, and Canadian law doesn't require them to seek your consent to hand that information over. So in terms of what can companies do to protect the information, there are a few things. Should they still try to store the data in Canadian cloud regions? Yes, because while it doesn't shield them from the Cloud Act, it at least ensures that Canadian privacy laws apply to that data for other reasons. In terms of agreements with a cloud service provider, you're going to want to have clauses in there that they should fight the request, even though they may not be successful. They may be able to narrow down the kind of information that they have to disclose, so it's not overly broad. And you're going to want to make sure that they notify you before disclosing the information. You're going to want to think about maybe hosting some of your data, maybe the highly sensitive data, and this is where strategy comes in, on Canadian-owned cloud providers, and there are pros and cons to doing that, and we can talk about it if we want to later. And perhaps most importantly, you're going to want to implement encryption and retain the encryption key, so key management on your end, as opposed to having the cloud service provider keep it on their end, is going to be really important because they really can't readily disclose data if it's encrypted.
Incredibly well summarized, Sharon. Thank you so very much. On the US side, we're actually pretty simple for the most part for most of our privacy laws, because we don't really have a lot of specific requirements about where that data can be stored. But what we do have is a newer law that really is the DOJ security rule. And this is regarding data that is sent to a select list of countries that the US government can change over time and that it deems as a national security threat. What companies do need to then consider is they need to understand the kind of data that they have that might be going to any of those countries. And part of that process is going to need to be, could it be going to a vendor? And does that vendor have anything also in that country? This is a new rule, brand new 2025 kind of situation that companies are needing to start paying attention to. So net, your data inventories that all three of us highly encourage everyone here to be having, you really want to understand that data inventory to figure out where is that global impact, who are those vendors, to be able to identify, could any of that data be going to one of those countries? And I encourage you to read the rules so that you identify which countries, because it can change. Like for now, it might be China, Iran, Venezuela, North Korea, and there's a few others that are there. So again, it can change, and that's sort of the end of our cross-border transfer. So if you're a US company and you want to put data in Canada or Europe or global, traditionally, other than, of course, good privacy hygiene, you can typically go ahead and do that. All right. Before we continue, I want to do our second poll. So our second poll is going to be, we've already given the hint on some of these, but US and Canadian privacy laws, and how confident are you in being able to identify the conflicting requirements? We've covered a variety of them so far. Maybe you're feeling more confident from 30 minutes ago, but let's see where you are today. Are you very confident, somewhat confident, not confident at all? This is brand new, never considered it, or not applicable to your role. So a few more folks are participating. I always think, I love polls. I like to see where people are. All right, a few more people voting. All right, gonna end the poll, gonna share our results. So 2/3 of you are somewhat confident. A quarter of you are not confident at all. If I were to ask this at the end of our call, I hope that would raise just a little bit. 4% of you hadn't considered it. We are glad that you are here. Thank you. 5% not applicable to your role. I'm glad you are learning. And the other 4% who are very confident, we are grateful for you. Please make sure we're saying the right things. So thank you so very much for participating. And Kat, I think now we're going to try and dig into the universe of health data. Super simple, right?
Super simple. I'm trying to answer a lot of the questions in the Q&A while we go, because I'm worried that we're going to end and then we're going to lose them. So hopefully if you're asking questions, I'm trying to, although there's a couple US ones, Jody, that you're going to have to go in there and answer.
I see them. We're going to get to them. Yep. Awesome.
So health, as we won't get too deep into it. The main difference between Canada and the US, and I think again, so we touched on this, HIPAA applies to things that have healthcare providers involved mostly, whereas in Ontario, health information is health information, regardless if you've had a healthcare provider involved. Like if you are using an app that collects health data, that is health data here. So our definition is different, and we we assign it differently, so it would be covered under our health laws. Again, each of the provinces has its own, and we are not like, it's like PHIPA, it's like PHIPA, and then there's like an HIPA, and then there's a PPHIP, like there, forget it. There's like that's the slide, one slide we could have used was the 25 different acronyms for the different health. Health is one area where our regulators are very strict about meeting regulatory guidelines. So a great example in Canada, if anyone's aware of TELUS, which is a massive company, TELUS has, Sharon and I know this too well, tools that work for pharmacies and health. Like they have a whole line of health apps, and they had one of their health apps was running in Alberta, and the companies that were using it didn't file a privacy impact assessment, which you have to do with health data. They didn't file a privacy impact assessment for that tool. And the Alberta commissioner said that tool cannot be used. And so again, TELUS, which is a massive company in Canada, was told that their health app could not run in Alberta until they ran the PIA and then fixed any of the risk mitigations that were required. So if you are creating a health app in Canada, you have to have a PIA on that health app, and it has to be sent to the commissioner in that province in order to be able to use it. So that I think is one of the big differences here.
So Sharon, anything you want to add from a health perspective before I share a little bit on the US side?
No, I think
Okay.
you did a great job.
All good. So when it comes to health here in the US, I mentioned HIPAA. That really covers health data, that it is the health insurance portability. It's about information between an insurance company and a variety of other providers. It is not only, I have what many would say PHI, personally, personal health information, or some actually have it as protected health information. It's a very nuanced. So when you go to a doctor, when you go to a hospital, that kind of health data in the US is covered. There are a variety, anyone who might touch that kind of data, even in an advertising context, a server that might store any of that data is a business associate. And there's this very complex web of who else might have to help comply or be a part of the compliance when it comes to HIPAA. But if I were to have a wellness app, or I'm a supplement company, or I'm in the yoga space, the fitness space, just like anything else that's health. I'm a IoT device that might be in the health space, not a medical device that might transmit specific information to a doctor or to some other place, just health related, something about our body. I am likely not covered by HIPAA. And then the question is, well, who covers me? Some of our state privacy laws that we were talking about would cover that. Now, one of the things I didn't mention at the very beginning that we have here in the US, we have the Federal Trade Commission. The Federal Trade Commission is able to kind of advise, and over some period of time, they've made rules and had rulemaking, and they've kind of gone after companies for two big things: unfair and deceptive practices. What that tends to boil down to is disclosure. Did I explain how my data is going to be used? Or did I do something in an unfair and deceptive manner? Which means if I'm any of those companies, I need to make sure I've disclosed properly the kind of data I'm collecting and how I would be using it. Then we have our state laws. So some of the states are starting to define health very broadly. In particular, we have Washington, the My Health, My Data Act, where a supplement company, that kind of data might be considered health data. If I were to buy, you could go on certain sites and you might be able to buy, I'm looking for women's health, or I'm looking for cardiac health, or I'm looking for fill in the blank kind of health, a fitness, maybe I'm taking a quiz on something, certainly IoT related information from some kind of health app. What were my running scores, or how well am I sleeping? All of those kinds of things might be considered health data. It is an incredibly broad law. So if you are in a space that has anything related to health, I highly encourage you to look into the Washington law. And then Connecticut, Colorado also have health, and some of our states have narrowed in health to really focus on reproductive health. So Virginia, for example, has some new requirements coming up where it talks about reproductive health. A lot of times it involves geolocation, the type of precise targeting that might be taking place, who that information is being shared with. So you kind of have to understand the kind of data. We have some that are reproductive health, some that are regular health, and then our good old-fashioned kind of HIPAA data that we have here in the US. Jody in Georgia, again, doesn't have very much other than HIPAA, and you have to be fair and not deceptive under our Federal Trade Commission Act.
Two very quick things to add. Actually, this is a US thing. The Department of Justice in the US has a new ruling that you can't transfer large pieces of sensitive data to certain other countries. And so that includes health data. We don't have that. But if you are in the US and you are sending, and there's thresholds, it's all in the ruling. Jody's nodding because I don't know if you've had to deal with this yet, but it's whatever. If you have a vendor that's in China, Russia, is it Venezuela? Who am I missing?
I'm pretty sure North Korea is there and Iran.
Yes.
And that's that DOJ security rule I was actually just mentioning. And you're right, health, like genomic data, biometric data are some of the kinds of data that can be included.
That has to be included. So somebody had asked in the questions, and we don't really have a section on this, about vendor assessments. You should be running a vendor assessment. I did throw an answer in there, but you should be running a vendor assessment on all your vendors with a privacy section in it. And that privacy section needs to include sub vendors that might be in those locations, but the sub vendors also have to have the same level of safeguards. So your vendors also, you have to deal with the cross-border transfers. You're going to have to deal with, do they have retention? Do they have the right policies in place? All of this wonderful stuff, but also are your sub vendors now outside. From a Canadian perspective, we do not deal separately with reproductive data because we have a better look at health data in general. But again, entirely huge topic is femtech and women's data. And because of the laws in the US right now, that can actually be harmful to women if people have access to their health data and their period trackers and all of that wonderful stuff. That's something to be aware of if you're developing a product or service for health that might track women differently. That might have some of that data in it. There's no implied safeguards in there, but you should be putting them in because there's a much higher risk to women with women's health data right now.
Yeah, and I want to emphasize the health piece here in the US. So health is often underneath sensitive data, and a lot of companies define sensitive data from a security standpoint. And we really need to expand that definition of sensitive data to start matching more of the privacy laws. And you really have to know where your data is here in the US because we have all these different individual states that have different definitions of sensitive data. Just like in GDPR, if you have to deal with GDPR, you're going to have your special category data. Well, when you start lining them all up, they're like some of them are together and some of them aren't. And then I kind of hinted where some of them are opt-in and some of them are not. So depending on who you are and where your people are and the kind of data that you might have to be opt-in and you might have to be opt-out. I love, Kat, that you added in vendor assessments. Whether you have health data or not, everyone should be doing vendor assessments. That's just a good best practice. And one of the best ways we love seeing those is from data inventories, because you're going to really understand Susie over here and her agencies and contractors and consulting firms and shadow IT that is being used in XYZ business process that the IT teams or vendor procurement teams may or may not have known about. All right, I think now we were going to talk about employee privacy.
Okay, I'll take the stage again. So from the Canadian perspective, if we were to look at our federal privacy legislation, PIPEDA, as a general rule, employees do not have a legislative right to privacy. However, common law has confirmed that they do have a reasonable expectation to privacy. So what I'm seeing is that a lot of companies are going to still enact all sorts of privacy practices around employee information, because a lot of it is actually sensitive information that they wish to protect and use in a responsible way. But then when it comes to employees trying to exercise a right of access, that's where employees, or rather employers, may say, whoa, you don't actually have that right because you don't have a legislative right to privacy. So there's a little bit of a, we really want to do the right thing by our employees, and then employers becoming a little defensive, like how far do we want to take this with our employees? So we do usually see employee privacy policies to just kind of explain to employees what their rights are. Now, in PIPEDA, that federal regulation that I was talking about, there's a bit of a carve out for federally regulated workers. So those are workers in banks and airlines and telcos, et cetera. And they do have a legislative right to privacy, and PIPEDA does apply to them. As well as in BC and in Alberta, as well as Quebec, they do have a legislative right to privacy. I do want to mention for those on the call, there's a new bill called Bill 149 coming into effect January 2026. It's called the Working for Workers Act. While there are many great components to it, mostly for employers with 25 or more employees. One part specifically, I think, is very important for all of us to know, and it's around the use of AI tools for recruitment purposes. So generally, what the regulation says is if you're going to use AI or an AI tool for recruitment purposes, you must provide notice that you're using the tool. The definition of AI in that bill is very broad, and it's very unclear whether you still need to give that notice for like a simple keyword algorithm search or like a full out algorithm that assesses the probability of a candidate's success. If you read the law, basically you have to give notice to all of the above. And I think the concern there is, and until we get some more interpretation, is that you're going to have kind of like a broad stroke notification where you're not giving enough information, and it becomes very difficult for the candidate applying for the job to know how you're using the data. Is it to assess the probability of their success, or is it otherwise? That may prevent them, or they may be a little bit more worried about handing over their information, or you may see a lot more access requests to see how you made the decision about them, when really it was just like a simple keyword algorithm rather than an assessment of their probability of success.
Very fascinating. Here in the US, I like how you were mentioning kind of legislative. Here we have California. From a privacy law perspective, California is the one that includes employees. So the California Consumer Privacy Act, the word consumer is B2B, employees, and regular consumer. So everything that's in the CCPA applies to Jody, the worker in California, and Jody, the B2B contact in California, and Jody, the person who buys too many things from Amazon in California. Every other state does not have a privacy law in that regard. There are a plethora of HR laws of what can and can't be used and monitoring. We have employee handbook requirements. So there's no shortage of employer obligations for what they are allowed to do, but from kind of like a comprehensive privacy law, it's really just California that does not give companies carte blanche ability to do anything that they want to. Highly recommend. We are very litigious here in the States. So I highly recommend anyone, if you are curious, can I collect this and can I not use this data? Really be working with your HR counsel. One of the things that was a really interesting story, it was, I think maybe 2 years ago, there was a company that was sharing birthday information. So they wanted to wish an employee a happy birthday. This particular person really did not want their birthday to be shared. They shared it anyways. They celebrated happy birthday. This gentleman was very, very unhappy. It's actually a public case. You can go and Google it. And that individual won, I think, nearly $500,000. So all from the sharing of a birthday when the person said, no, please don't share my birthday. There wasn't necessarily a law that says you can't share my birthday. So you want to really be mindful for what is okay and what is not okay. And it's not always the law. I always like to say just because you can doesn't mean you should. So you really have to factor those pieces in.
Ontario also has an employee monitoring policy requirement. So in Ontario, you have to produce a policy internally that tells employees what you're monitoring. And people often miss that. They're like, oh, we're not watching, we're not using that kind of thing. But Teams by default has all sorts of wonderful new AI monitoring stuff that tells you how long your employees have been online, which meetings they signed into. That's considered monitoring. So this isn't like how many CCTV cameras do you have in your office. This is, are you tracking people's badge in and badge out? Are you monitoring them? Do you have like company owned phones and you're able to get their location? That all has to be laid out in a policy for employees.
Thank you for sharing. Okay, so privacy notices. Who wants to take the Canadian privacy notice obligations?
I can do it really quick. I don't think that our notices are going to be significantly different than yours. We have the typical, well, what's the purpose of collection? What are you collecting? Who are you sharing it with? What's the protection? To the extent that I guess some companies will include information about cookies unless they have a separate cookies policy. So we may see that. We see retention, of course, the rights that you have, how to opt out of consent, because again, consent is that big thing in Canada. Contact information of the privacy commissioner, should you want to file a complaint, as well as the contact information of the privacy officer. But one thing that, and I don't know if it's specific to Canada, but it's definitely something that we do need to include. It goes back to that cross-border transfer. If data is going to be transferred outside of Canada, or for Law 25 in Quebec, outside of Quebec, you do need to inform the individuals in your privacy policy that the information is going to be stored outside of their jurisdiction, as well as what the consequence will be to them that their data will not be in the same jurisdiction that they reside in. So for example, looking at some language that I usually use, I will say in terms of the consequence, it may be that government, courts, law enforcement, or regulatory agencies of that jurisdiction will be able to access personal information through their applicable laws. So that way individuals know my information may be accessible to those parties. In terms of government agencies, you're also going to want to list out any statutory authorities for the collection of the information. So what's the basis that you're collecting my information? Where does it say that you can do so according to the statutes?
In the US, I mentioned we have the Federal Trade Commission. So that is all around that disclosure, not being deceptive, and being able to, Sharon, just like you described. And we also have some state laws that just long time, couple decade old state laws that say you have to describe what you're collecting, how you're using it, where you're storing, not where you're storing, who you might be sharing it with, like general concepts. I might share it with financial payment providers. I might share it with these kinds of third parties. And nowadays, privacy rights as well. However, here are some of the special nuances that we have. The California Consumer Privacy Act, CCPA, has some very specific requirements. It is not required to be a chart, but many companies end up creating a chart to make sure, because it's kind of the easiest user experience to be able to fulfill understanding the 11 different categories that CCPA says, how that data might be shared with a third party. Is that data being sold to a third party, as well as the business purpose that is actually happening with that data. You also have to have separate disclosures. If that data is sold within 12 months, some companies have to disclose the number of privacy rights that they have honored. You have to list all the different privacy rights there. Back to health data. The Washington My Health, My Data Act requires a separate special privacy policy. And then we also have special policies for HIPAA. We also have special policies for the Gramm-Leach-Bliley Act. So anyone here who might be a financial institution, you might have that privacy notice to cover that type of data, but that doesn't absolve you from the rest of perhaps your website and regular information that you might have. And in particular, Oregon, if any of you here have people and you are in scope for Oregon, and if you list in your privacy notice, we honor privacy rights, and you start listing all the states, make sure Oregon is included. Oregon really wants to be included if you are there. So little fun fact. And the last fun fact I'm going to share is if you have privacy rights in your privacy policy, regulators here in the US are using the privacy rights process that you disclose in your privacy notice to send you their their inquiry. So if they have something that they want to ask your company about, they want to send you a letter, many of them are using the privacy rights process as a way of testing, is it actually working, to send that. So make sure your process is working. Have someone actually managing the email box and the inbox. Oh my goodness, we have covered so much, and there's still so many other topics that we wanted to cover. So Kat, I'm going to let you pick your favorite one that you think you might want. In the last few minutes, we had kids,
AI or
we had
kids?
AI.
Okay, well, we don't have a kids thing, so we'll just leave it. We don't have one.
The kids aren't protected.
So AI is a really big thing for privacy. There are two parts to AI. Canada is not covering either. Jody can speak to the US, but really no one's covering this properly. The best guidance we have for AI, if you're looking to help your company, is actually the EU, because they have established the AI Data Act themselves. They have frameworks, they're downloadable. You can get a checklist of questions. There's two areas of AI for privacy that you need to consider in your company. The area number one is how are you using AI internally to help you function as a business? Like, are people like, hey, I'm just going to dump all this stuff into AI and have it create a deck for this meeting? I've seen that happen too many times. They're like, hey, we got 16 different clients who did this thing, so I'm going to dump all their data into OpenAI and then generate a report. So there's that version. And then the other piece is, are you using AI in order to improve your product or service? So you need an internal policy, which again, nobody is stipulating, but we're saying you need an internal policy to guide AI governance and ethics within your company on how your employees are allowed to use AI. Because you should not be sticking any kind of sensitive data into any kind of open AI system at all, or not specifically open AI, but any kind of LLM. And then from a product perspective, if sensitive data is going in, again, like I see too many people trying to build new businesses. Like I do a lot of consultancies on people like, hey, we're going to do this new thing, and to get it off the ground quickly, we're going to use an open AI model. You can't do that because you're dumping sensitive information into the public and you're sending it out. So if you are developing AI, you have to develop it right. You can't do a quick and dirty model. And the best way to do that is to have AI or have your models running individually in a box for the companies, like for your clients. So none of that is legislated. I'm just throwing in a bunch of, because AI is such a hot topic right now. A whole bunch of, here's what you should be doing. Because when the regulations finally come in, you don't want to have to scrap 1 to 5 years of work because you've set it up in a way that isn't privacy first.
Excellent. We have no national AI legislation here in the US. Colorado is the first that is set to become effective in 2026. Utah has some that they have passed as well, pretty narrow slices, and a lot that is being considered and on the books. And I will say, for all privacy laws, personal information is still covered by a privacy law, even if it's entered into an AI tool. So in that regard, privacy and AI are still interchangeable in that regard. So we have just, oh my gosh, like a minute or so left. We have tried to answer so many of these questions that are here. There's one in particular that was going to be way too hard to type, and I wanted to address because it's a pretty big one. Here in the US, we have CCPA, and one of the obligations is to be able to share downstream the opt-out. And it is the company's responsibility to share that downstream opt-out. And it kind of depends on the certain situation. But for example, if you knowingly shared data to company A is using it for themselves, I go to you to opt out and stop that sale, you have to go and communicate to that other company. So it's part of the process to try and figure out how to make that happen. As you can tell, there is so much to talk about. Sharon and Kat, I'm so grateful that you joined us here today. And everyone listening, thank you for joining our party. And if you are not already connected, I know I can speak for myself. I would love to connect with you on LinkedIn. Sharon and Kat, where's the best place for them to find you?
LinkedIn would be great. We'd love to connect.
Yep, same.
Amazing. So many people asked for the recording. This will be recorded. We will send this out. We are again so grateful for all the questions and interactions and for you joining us today. Thank you so much.